Hello, YouTube. I'm Vince White. I'm an employment attorney, and today we're talking about like a subtle topic. It's a little bit subtle. Okay, so there are a couple of non-attorneys on YouTube that run channels giving advice about like employment law in general or representing yourself in the EEOC, things like that. And a couple of these channels, some of them are run by people who experience the EEOC process as, as a complainant, as somebody who filed, as a plaintiff, right? And I think that is incredibly valuable. I think that is really, really valuable to have those people sharing their experience as a plaintiff, as a complainant, as somebody who filed, as somebody who lived those events, who experienced those events, experienced the emotional trauma of those events, and everything else. And almost all of these people are very upfront about the fact that they are not attorneys, which is important, I think. I think it's valuable. I think it makes what they're doing fundamentally okay and a good thing, right? But there are a couple issues with what some of these channels are doing. And I'm not going to pick on anyone. I'm not going to link to anyone because I think 80% of the information out of these channels is good and helpful and valuable. And because these people are doing work that, frankly, attorneys in my field are not doing, because I don't think there's enough attorneys from my field on YouTube. A lot of them get on YouTube, make like 20 videos, and they're like out, right? And that's not, it doesn't cut it. It's not enough. You haven't scratched the surface yet at 20 videos. Like we're making a video a day. We've been doing it for years, and I got 20 questions I got to answer here. And, there's a lot to be done here. 20 videos is not going to get it done. So these non-attorneys are doing that work because, frankly, the attorneys are falling short, right? Not enough of us are doing the work. But there's a problem. There's some issues. Okay, so first off, there's one individual does a really great job. Great graphics, great presenter, lived the EEOC process. I think she was successful in her claim. Does great work. And again, 80% of it is tremendously correct and right and valuable. I've watched a good number of her videos. There's a couple things going on that make me say, this isn't the best. One, I'm not sure, based on the videos I've watched, that she understands that there is a different experience for federal employees versus private employees when they file with the EEOC. In fact, there's almost no connection. There's almost no similarity between what a private employee experiences at the EEOC and a federal employee experiences at the EEOC. So some of the things that she said, they're true for federal employees, but she doesn't really specify that. That could really get a private employee into a bit of hot water. Really not ideal. Also, there's some tendencies across some of these channels to try and give voice to evidentiary standards or to use words without perhaps taking the time to understand what that word means in this industry. Like, I'm not going to give examples because I don't want to deride any of these people. But there's just words that are used that are in common parlance that mean one thing outside the world of employment law, right? They mean one thing when you're talking with your buddies at lunch or you're at work or anything else, right? But in the world of employment law, they mean something entirely different. And there doesn't seem to be the biggest attempt to understand that and wrangle that or express that, right? I'm doing a video on hostile work environment coming up. Hostile work environment, everyone assumes means stuff's hostile at work. That is not what hostile work environment means, right? The issue is, if you do a video about hostile work environment and you don't explain what hostile work environment actually is, then a bunch of people think if they're having hassle at work, they have a claim. And they might behave as if they have leverage they don't actually have. And that means they're just out there fighting with bringing like a banana to a gunfight, right? Like it's not a good situation. So they're potentially misleading folks in a bit of a dangerous way. Some, I've seen a couple videos about evidentiary standards. This is how you prove your boss is bad. Okay, well, that's not the evidentiary standard. The this is how wasn't actually a statement of the evidentiary standard. And also, if you prove your boss is bad in the EEOC, you proved your boss's defense. Right? The EEOC is not looking for bad bosses. Bad bosses are legal. The EEOC is looking for workplace discrimination and workplace sexual harassment and workplace retaliation tied to workplace discrimination and workplace sexual harassment. So if you prove your boss is the worst guy ever, that employer is going to say, yeah, he's a real jerk. He's a jerk to everybody. Equal opportunities jerk. Thank you for making our defense. We agree. We agree with everything you said. Thank you. And these non-attorneys, in the videos I've watched, I don't really know some of that stuff. So what I would say is that content is valuable. Is valuable. It helps people. I think it's more valuable when they're talking about their experiences as plaintiffs, as complainants, as people who filed, right? As people who went through workplace discrimination, went through workplace sexual harassment. That is incredibly valuable. It is slightly less valuable when they're talking about things that they've done once, right? So if you're listening to an attorney's channel, a valid question is, hey, attorney, how many cases in this field you run a year, right? For me, it's somewhere between 200 and 450 a year, right? And I've been doing it 13 years. So I have a lot of repetitions under my belt in terms of running employment cases, right? Working on employment cases. This is something that I've done over a decade. And let me be clear, there are many attorneys who've done far longer than I have. But I've had, because of the nature of our firm, because of the volume our firm handles, because I think we may handle more cases nationwide than potentially any other firm in our specific narrow field, right? We get a lot of repetitions. And that's at every aspect of this battlefield, right? So the press, the litigation, the agencies, the arbitration, the mediation. And I spend time. I work as an arbitrator. I work as a mediator. My primary occupation is representing victims of workplace discrimination, workplace sexual harassment. So I spend 10 hours a day, 12 hours a day working on that, thinking about that. That is slightly different, I think we need to acknowledge, than someone who's had one case, right? If you had one case, you're really, really able to anecdotally share what you experienced. And that is tremendously valuable. Again, I cannot stress enough. Good channels, good people doing good work. Just there's got to be some level of like not talking about what maybe you don't understand. Or even just run it by an attorney if you're going to post it. Or if you're digesting, if you're taking in that content, don't be afraid to just be like, hey, I heard all I got to prove is bad faith. For what? In what context? What are you talking about? Let's talk about it. Like, hit me up. I'll talk about that. If you think the evidentiary standard for your case is got to show the employer acted in bad faith, okay. I have concerns for you. And I think we should talk about that. We should get into some details. We can do that on the channel. And hash out specifically what the evidentiary standard is, because the evidentiary standard is like a punch list, right? These are the things you must prove, otherwise you lose. And I don't want you to lose because somebody gave you the wrong checkbox, right? The wrong check boxes to mark, right? Like, you need if you're going in and you're representing yourself and you're going to do this fight on your own, you need to know your win condition. You got to know, I need to do X, Y, and don't forget Z. And if you forget Z, you need to understand you're going home and it's not going to be a good day. So, just digest the content. Take it in. It's valuable. It's prettier than mine, frankly. The videos, the graphics, everything else. The presenters are really talented. These are talented, intelligent human beings who've been through a case once, maybe twice, and they're doing good things. They're helping people. They do, there might be one or two of them that are monetizing it, which I don't know how I feel about monetizing a YouTube channel on a topic that you don't really have a depth of knowledge in. I'll teach you all about whale sharks if you want to pay me. I know a whole bunch about whale sharks. They're big. They're sharks. I can easily do 70 videos in just those two things. Okay, I admit, my depth of knowledge about whale sharks, very meager. And so I feel compelled, strongly compelled, to not do a YouTube channel about whale sharks. I could do a YouTube channel about one time that I scuba dove with whale sharks. One time. That could be fun. It could be helpful. It could tell someone else some of the things that I experienced while scuba diving with whale sharks. And it might have some valuable things like, oh, bring this. Talk to your scuba diving instructor about that. Make sure when you're hiring a scuba diving instructor, you talk about this. Right? These are all valuable things. These channels matter. I cannot stress enough. They're good channels with good purpose and good value. I just don't think they should necessarily be describing concepts they don't understand. And these are not, like employment attorneys are not rocket scientists. If you do the reading on a given topic, you can very rapidly get the elements. Understand the evidentiary standard. Understand what a term means in this field. These are not great and demanding tasks. They're not. They're not. Now, they're a kind of a hassle. People don't want to do them, I get that, but, you're trying to help people. Sometimes actually helping means actually taking the time to understand what you need to say. Just a thought.